All right. I would like to ask Senator Roth if he would respond to the concerns that I think have been very personally and dramatically suggested from people who have experienced the impacts of minor matters. I know that there is, if I'm not mistaken, still a right to sue if someone actually has physical injury, but clearly there are other injuries that take place as well. If you would respond to that, and also the suggestion that notice and right to cure grants immunity without a penalty, and that is contrary to civil rights law and other aspects, as I understood the testimony of the gentleman to be. If you could start with those, and then I'll open it up to questions from the other members.
Thank you, Madam Chair. First, let me say there's appears to be a lot of misinformation out there. I think it's occasioned by the way we process bills here, where we do a bill and then there are amendments that are accepted, and not all of the amendments are connected with the original bill. That's certainly true in this case. This bill has nothing to do with giving someone a notice and then allowing them to fix something after they receive a complaint. The 90-day notice and opportunity to correct is very narrow. It applies to those businesses that elect to spend the money to try to bring themselves into compliance, to get an inspection, to begin work on the inspection. It allows those businesses a 90-day moratorium, if you will, to fix whatever they can fix. And if they don't get it fixed or they choose not to act on the report, then the full remedies associated with the UNRU Act, the full remedies associated with the California Disabled Persons Act, the full remedies associated with the Americans with Disabilities Act apply. It also does not exclude individuals who are injured from filing a lawsuit if they're injured during the 90-day moratorium period. So the testimony where individuals were tragically injured by visiting a business, they would not be precluded from accessing the court system and receiving their day in court and receiving the damages that they're due for the injuries that they sustained. So as to that point, as to what has been referred to as a minor matter or the minor matters portion of this bill, no bill is perfect, and this bill is certainly far from it. I will admit to that. That phrase was not a phrase of mine, but rather a phrase that was inserted during the bill drafting process here in the building. I don't consider these technical issues to be minor. They're not minor to me. I know very well from hearing the testimony that they're not minor to the people who've presented here today. But keep in mind, we're talking about, one, a small business, so it's not the larger employers, it's a small business, 25 or fewer employees. It gives that small business 15 days from the date of some notice, can be any notice, to do what? To correct a sign. And remember, the signage changes from time to time in this state, and how do businesses find out what the current sign is? Nobody sends them a notice. One year the sign said no parking, the next year the sign said $250 violation. So it gives a small business 15 days to post the correct sign, and it gives a small business 15 days to freshen the paint on parking stalls or spots that are correctly dimensioned with correctly dimensioned access aisles and other components that are called for in the business standards. We are not excusing or accepting any business that does not have exterior parking that fully complies with the ADA standards in the California Building Code. It is simply freshening the paint on paint that may be faded. It is simply posting the correct sign where the signage requirements may have changed 1 year or 2 years before. And that is the beginning and the end of the provision that has unfortunately been labeled a minor matter provision. I prefer to call it a technical but important violation. I hope that addressed your questions, Madam Chair. All
right. Thank you. And I know there are other questions from Senator Anderson and then Senator Morlock.
Senator, when I view your bill, I don't see it as a bill that is trying to help people not comply, but rather giving people who wish to comply an avenue to do it. These rule changes come at any time. There's no set time. They come all year long. What worked today may be a violation tomorrow. And I think that it's a terrible shame when it's so difficult for a company that wants to do the right thing to fail. And typically these small companies, I have them come into my office all the time. Some of them, are working as hard as they can to try to comply with the laws, but they change so rapidly, it's very difficult for them. And because they don't have large margins, everything that they pay out frequently prohibits them from investing to comply with the law. And they don't think of it in terms of complying with the law. They think of it in terms of gaining access to more customers. It's not in their best interest to have a facility that does not allow everybody to purchase what they're selling. And what I like about what you're doing is that this isn't helping people to avoid the law. This is helping people who are trying to comply do it in a thoughtful manner. And I listen to the witnesses, and I feel horrible about it. I don't want them not to have access. Of course we want them to have access. But I think it's a further, it doesn't help the issue further to put the goal line further out from the companies that are trying to comply. So I'll be supporting it today, and I'd like to be added as a co-author. I think this is a very thoughtful approach. We can't be perfect. I think you're right. Nothing's perfect when you get to this area of the law. However, I think that you've really eyed the needle as best you can. I mean, you've given a time certain, and you've really looked at the long term of it. So I'd like to be added, and thank you for this thoughtful bill.
Thank you, Senator.
Thank you. Senator Roth, I'm just curious about the tax credit component. Is this new? Because it seems that there's already a tax credit of this nature. And so I'm just curious, could you tell me what's new or different or improved?
Well, I'm not a tax specialist, and I certainly defer to those who are, but it's my understanding that there is a tax credit that's provided under federal law for small business. And my understanding is the tax credit is, correct me if I'm wrong, somewhere around $15,000 of a tax credit. But this provides a tax credit under state law, and it provides a tax credit for up to $15,000, $15,250 of demonstrated expenditures. And so the point is, we're trying to encourage particularly a small business. We're trying to encourage a small business to spend the money. We're trying to encourage businesses generally, but particularly small business, to go out and hire the certified access specialist, to dig into the genes and find the $2,000 to $5,000 to do it. We're trying to encourage the business to go further, and once violations are identified, to fix those violations by spending the money to get them fixed. In many cases, a $15,000 expenditure cap will not do it, but it goes at least some way, some direction down the road to trying to help businesses get in compliance, to try to avoid the sorts of problems that we've heard this afternoon.
In a prior life, I used to be a tax accountant, and I haven't prepared a return in 20 years, so some things have changed in that time. But there's a Form 8826 Disabled Access Credit, which is providing the numbers you're talking about for the federal tax return. And then the state has a Form 3548 that's already providing the credit of one-half of $250, and it provides for in the explanation for the form that you get remove architectural, communication, physical, or transportation barriers that prevent a business from being accessible to or usable by individuals with disabilities. And so I'm just kind of confused. Are you providing something new, or are you extending something? Because I couldn't find a deadline.
The state tax credit of $250 will not pay for 1 hour of, it's my understanding, 1 hour of some certified access specialist time, because some of them bill at the rate of $275 an hour it's my understanding, to inspect a facility. So my intent in this bill is to expand the state tax credit consistent with our budgetary limitations. It has a sunset on it. We are developing, and I'm committed to develop the various criteria that were set forth in Senator Leno's bill, I believe, of last year, having to do with performance metrics, goals and objectives. We're working on those now, and I would be pleased to share those with this committee as soon as I have that detail together. I'm a firm believer in tax credits only if tax credits produce the designed and expected result. So we will develop performance metrics to make sure that these tax credits do that. And if this tax credit program does not bring about the desired result, which is compliance with the ADA access standards and encouraging business owners to make the sort of improvements in their facilities that they need to make, then we will deal with the elimination of the tax credit at the appropriate point in time.
And then great, just the briefing that I have says the maximum credit per eligible small business per taxable year is $125. So maybe we all ought to work on your bill a little bit to make sure we're getting the results that you're looking for.
Well, this bill has a tax credit built in of $15,250, up to $15,250 of actual expenditures.
So rather than get into a discussion about tax, which we all know is fascinating, can we just try to stay with the policy here? Well, I'm sure that if there are concerns, you can express those with Senator Roth, who has several other items to deal with in the policy in this as well. Are there any other questions? All right, Senator Leno.
Thank you, Madam Chair. Senator Roth, thank you for your admirable efforts and for all of those who have come today. It's a very heartfelt subject, we know that. I did want to ask a couple questions, please. On page 11 of the analysis, where there is the suggested amendment, which I believe you have taken, the analysis goes on to comment at the bottom of the following paragraph that the author should continue to work with stakeholders to ensure that the above provision reflects your intent and does not preclude persons who were actually denied access from bringing a suit for statutory damages. You have mentioned for people who have been physically harmed would not be precluded. Is it in fact your intent? And does the amendment you're taking reflect that intent, that there would be no preclusion for individuals who've actually been denied access for bringing a suit?
Senator, that is my intent. It is my understanding that the only thing that is excluded during the 90-day period, the moratorium period, is claims for statutory penalties, which would be the $4,000 or the $2,000 or the $1,000 if the categories apply. So those would be the only damages that would be excluded. So all other remedies are available. Claims for actual injuries, claims for injunctive relief under the federal Americans with Disabilities Act. And to the extent that that's not clear enough, we'll make it clear.
Okay, that would be helpful. And then I know we're also trying to address the well-known fact that there is a small group of bad acting attorneys who are filing a lot of suits that don't result in greater access or greater compliance, but puts money in their pockets. Is there a way to identify what are sometimes referred to as the frequent filers? So for those who have hit a certain threshold of filings, that there could be some sort of court review, which I'm not even quite sure what that would entail, but some way to say you hit this threshold, we're going to further scrutinize your filings.
Well, the Senate bill, I think 1186, Senator Steinberg, Senator Dutton's bill of a couple of years ago, had a requirement that certain documents be forwarded to the State Bar Association. There was a sunset. This bill eliminates that sunset, so we still have that provision, so that there will be some review on some of the documentation that is served on business owners by lawyers. there are some other procedures in 1186 which deal with some of that. I attempted in an original version of this bill to deal with what some people, this is not my term, referred to as serial filers, but the issue became a little complicated and too complex to deal, frankly, with in this bill in that way.
And then just one last question. I know you've been meeting with all stakeholders, including those who are opposed. Is there anything that you have heard in those meetings or anything that has been presented today, given that you have acknowledged that this is a work in progress, that you would give further consideration in acknowledgement of some of the oppositional voices that have been expressed?
I intend to continue to meet with all groups on this issue. Should this bill move out of this committee, I intend to continue my conversations. I immediately met, as I started this effort, with various representatives of the disability rights community. People come to issues from different directions. I rapidly found that there was not always agreement on the proper way ahead. I attempted to resolve, I won't say disagreements, but differences in approach. Sometimes I was successful, sometimes I was not. There is a basic issue with the notice and opportunity to correct concept. I tried to limit this in a way that hopefully encourages businesses to use the Certified Access Specialist process, the CASP process, because whatever it is that we have been doing over the last 10 or 15 or 20 years is obviously not working. And so we need to do everything that we can do within our power as a legislature to encourage business, to drive business to CASPs, to encourage business to have their property inspected, and to encourage business, whether it's through tax incentives or otherwise, to get the problems fixed so we try to avoid the situations that we've heard about, the tragic situations in some cases that we've heard about today.
And I very much in support of and appreciative of that aspect, because I think they are true incentives. And that's something we want to continue to encourage. And I'm not asking for any commitment here today, but rather, in addition to further conversations, is there any issue area that was brought up by oppositional voices today that you think could potentially be incorporated into the bill as it is moving forward? Is there anything out there that you've heard that you're sensitive to and that you think, in fact, could be incorporated?
Well, Senator, obviously I need to continue to sit down with groups on all sides to discuss this opportunity to correct issue. I need to make sure that everybody completely understands what this bill is amended, if it goes anywhere, what it actually does. I need to make sure that people and associations understand what my intent is, and then to the extent that I can make this bill better and to accomplish the objective in either this way or some other or modified way, I am perfectly willing to do that. I have a goal, and the goal is to increase ADA compliance in the state of California, to avoid situations where small business owners or operators come up to me and say, I got inspected by the building inspector when I opened, and I thought I was okay. And I say, oh, no, you weren't. They say, my building was built in 1921. I'm grandfathered. And I say, oh, no, you aren't. I talk to building inspectors, and I have a group of building inspectors, and I ask them questions, and they can't even agree among themselves what the standards are and how the standards are to be applied to businesses. We need to do whatever we can in the state of California, both as a state government and at the local level, to fix this problem. And I'm committed to do so, Senator.
I am glad to hear that, and I don't doubt you one bit. I probably, like all of us, have heard often from small business owners in my district about some of the abuse that is going on. I remain very sensitive, as I know we also all do, to concerns of continued lack of access and less than respectful and dignified responses to those who are being kept out. And so that's the fine balance here. I know you're trying to address it, and appreciate your efforts. I also appreciate all the comments made today, because I know that they are real and heartfelt. We're trying to find that delicate balance here. Thank you.
Thank you.
Senator Monti.
Thank you, Madam Chair. I also want to thank the author for his thoughtful approach and an accessible approach. I heard the arguments at the time of SB 1186 and trying to find that balance in what evolved with the ability to stop immediate demand letters and have some state bar oversight. I do share the concerns raised by some of the opponents. I'm sorry I missed some of the presentations and had to be out of the room, but I do understand from my colleague Senator Leno that the definition of minor violations, your response to that I didn't hear myself, but acknowledge that a violation is violation, and it may be a technical violation, but in the experience of somebody who's being denied access, or even if it's not total denial, if it's interference with access, in the experience of the disabled person, it is not considered minor. So I appreciate your sensitivity to that. I think, like every member here, we hear from our business owner community and we hear from members of the disabled community. And some of the arguments that stuck with me most powerfully from the last round of this is that there's no other protected civil right where we afford a violator, somebody who engages in discrimination, an opportunity to come into conformance with the law. And so in essence, the message to those living with disabilities is that we honor your civil rights and we see your right to access as a fundamental civil right. But in this arena, we're going to have a separate set of rules allowing people to come into compliance. And it does sound like a second-class treatment at times. That said, I think the effort that's before us today through SB 251 and the inputs from disabled community, but also from groups as diverse as consumer lawyers and Chamber of Commerce, is the real objective is to encourage and promote compliance, translating to access. That we want California, I want California to have the reputation of being the most accessible state in the nation. And I think we've led the way in many arenas, from sidewalk ramps and other pioneering forms of disability access that have been replicated around the country and around the world. And I just hope we can see this vehicle as it moves forward is also championing greater access for all, and that, as I think Senator Anderson alluded, it's logically in a business's interest to be accessible, but we don't live in a world where everyone looks at those with disadvantages, disabilities, gender, race, whatever it might be. We live in a very multicultural, diverse culture, but one that also has people that are not accepting, are not open, that do treat people with discrimination. And some of the reports we've heard of how people have been addressed in trying to assert those rights, that should be actionable as well through a form of defamation or discrimination. That's not what the bill today is about, but it is connected to that, because part of the success of this vehicle, I hope, will be to further stigmatize those who discriminate, whether they're a business owner or whether they're somebody who feels interfered with because they parked next to a disabled parking space and are somehow put out by that. So I look forward to following the course of this legislation. I'm going to be supportive today, but I do look forward to the continued voice of all stakeholders, and perhaps most importantly, that of the disability community that is the community that has, in many ways, the most at stake in how we move forward with this. So thank you.
Thank you,
Madam Chair.
Thank you. I'm just going to say a couple things and then ask you to close. You know, I'm recalling now as a youngster that one of the things that we had to do in my 4th grade class was to spend a day in a wheelchair. And it was quite an eye-opening experience, just walking, just getting from place to place where you never thought anything about it. Suddenly, you appreciate how difficult this is, the challenges associated with the bumps in the road, and how do you get into a car, and how do you get, as you say, to a restroom. And I think part of, and that was probably one of them, I'm thinking back on my academic career, it's probably one of the most important experiences that I had, because I think we don't appreciate the challenges that other people have going through the kinds of day-to-day routines that for most of us, we can't comprehend. We just haven't experienced, and how little consideration we give for the things that we have that others don't. And so I think that in hearing you today, it reminded me and hopefully all of us that life isn't really quite so simple, that the notion that someone blocks your access to your car can mean hours of not being able to go where you need to go. That just things like this. And so I want to thank all of you for presenting your life experience so that we might all have that in mind as we take a look at legislation that really isn't necessarily about tax breaks or more customers. It's about human beings and what it takes for you to live your lives and to live them as well as you do. So I wanted to share that because I think it's important as we go forward that we make any legislation we pass address the actual problem, which seems to be that we are denying people their access to what we have made very clear in the Unruh Civil Rights Act back in 1969 is the right of every person. At the same time, it's very clear that many business owners are just simply not aware of the protections that are, to which you are entitled, or that they're violating. They just don't think about it. And in many instances, they assume when they get that building permit that they have complied with the law. And perhaps one of the questions we should be asking is whether that building permit should include information. Because if you don't read the building permit, or you ignore it, or you don't comply, you've had notice, you've had knowledge, and before someone comes in and is impaired and impeded in their access, you will have had notice. But most businesses, small business, don't know that what they're being told is not the full story. So we're saying one of the ways we're going to deal with that is with these CASPs. And when legislation was passed in 2012 that included this concept, it appeared to make somewhat of a difference. But I'm impressed by this series of letters that you've been writing over the past X number of years, 90% or more of which have gone unheeded. So clearly what we've got is not working. This is not working. Allowing people to run around and file lawsuits doesn't work either. And I think that's why the consumer attorneys are here today, because there are circumstances where filing a lawsuit doesn't get the result that we want. And I think that's the sort of the tension, the balance that we're trying to achieve here. So I think we need to say, and I know that Senator Roth is very, very clear, that denying equal access or limiting the right of the disability community to enforce its right to equal access is also not acceptable. So the challenge is, how do we bring all of those things together so that you don't have to keep writing those letters and they don't keep getting ignored? So I think the goal should be to promote compliance, by ensuring that businesses have the information they need, because I think most businesses want to do the right thing. They just don't either know, or they assume otherwise, or they have to wait to be told they're not complying, and that isn't acceptable either. So I know this bill is a work in progress, and I want, and I believe I will elicit from Senator Roth a commitment that if this bill significantly changes, it goes through the process, that it will come back to us for further consideration in hopes and in expectation that that balancing of very serious and important factors is met. I don't know if we're ever going to get everybody in agreement, but I think this is the goal that you were trying to achieve, and the one that I know my staff and I have been working hard with you and with the communities to accomplish. So with that, I will accept the motion and ask you to close, Senator Roth. Just a clarification, very briefly. We've spent quite a bit of time.
Thank you.
I know it's worthy of it, but just very briefly,
Okay.
a brief clarification.
Everyone's been talking about statutory penalties, but these are not penalties. They're damages. Just if you're discriminated against based on age, race, sex, we acknowledge that discrimination's horrible, it's bad, we don't want you to suffer it, we're not going to make you prove to a court that discrimination's bad. You get statutory damages. These are not penalties. Penalties are to punish. Statutory damages are to compensate.
Appreciated. Much appreciated. Senator Roth heard that, and I appreciate your comments, bringing it back to the spirit and the focus of the Unruh Act. Senator Roth.
Thank you, Madam Chair. First, I want to thank all of the participants in this process, particularly the participants in opposition to the bill, and I want each and every one of you to know that I have the highest respect for you. I have the highest respect for your advocacy and your focus on this issue, and I pledge to work with you and your organizations to achieve what we're talking about here, which is equal access for all. Madam Chair, this is a very, very difficult bill. I acknowledge that, so I want to thank you and the members of this committee for your patience, and I respectfully ask for an aye vote.
Very good. Is there a motion?
So moved.
So moved by Senator Anderson. Madam Secretary, the motion is due pass to Senate Governance and Finance with amendments to be taken in that committee. Very good. Madam Secretary?
Jackson.
Aye.
Jackson, aye. Morlock. Anderson. Anderson, aye. Hertzberg. Leno. Leno, aye. Monning. Monning, aye. Wykowski. Wykowski, aye. Hertzberg. Aye. Hertzberg, aye. Morlock.
I'm real concerned about the credit. I'll be.
Right.
6-0, that goes out.
6-0, that measure is out. Thank you, everyone, for your heartfelt testimony and excellent suggestions. Senator Roth, thank you for your good work on this. Much appreciated.